Hi, everyone, and welcome back to the Crypto Law Podcast. My name is JW Verrett. I'm a former guest here and ally of JD and the XRP community in the fight to support Ripple's rights. I sit on the Zcash Foundation board. I teach corporate securities, banking, law, and forensic accounting at George Mason Law School. I'm joined by Megan Day, a student at George Mason Law School, who is my co-author on a paper we're going to talk about today. Megan is also got the inside scoop on what happens at the SEC. She's a former staffer for Commissioner Hester Peirce. She's going to be clerking in Delaware after she graduates, and she co-authored this piece with me that the team at one of the prominent crypto exchanges is called Nothing Less Than Brilliant. So we're going to have a chance to talk about all of that. Bios aside, I want to mention at the outset, just mention a case I've been working on that I hope folks will pay attention to and keep your eye out for. United States versus Sterlingoff is a case that potentially threatens the rights of everyone in crypto, the privacy rights of everyone in crypto. So I worked as a pro bono expert on this case, as a forensic accounting expert, to help out the attorneys. I wrote up my experience there. Unfortunately, he was found guilty last week in what was a real kind of a punch to the gut. It was a good professional opportunity for me to be on, but I ended up spending about 30 hours with him in prison, got to know him. Became really clear to me that he's innocent of running the mixer. They said he ran. He was a user of it, but not the guy who ran it. It's a case that threatens everybody's privacy rights in crypto, and the ability to use encrypted money, which is so foundational to everything crypto is about and everything the cypherpunks were trying to build. So I hope it's a case you'll keep an eye on. The appeal continues, and I have every expectation that we're going to win the case. And the lawyers in the case, Tor Eklund and Mike Hassert, or absolute lions in the courtroom, and wait till they get their hands on that appeal. I have high confidence for what's going to happen there going forward. All right, so good news. Good news I want to focus on. They say you can't fight City Hall, but sometimes you can fight City Hall. And the debt box case is a case of regulators run them up, but being held to account by a U.S. federal judge in Utah. So in debt box, this is a case where the SEC was going after a defendant debt box. In a portion of the case, one of the SEC lawyers misled the court, clearly misled the court, and said, Your Honor, we need a TRO. We need to freeze all their assets because they're going to move them all to Dubai. And when the court had some tough questions for the SEC lawyers, said, how do you know that's going to happen? He said, well, they have a YouTube video about it. The judge actually watches the YouTube video, and the YouTube video shows somebody talking about potential benefits to maybe operating a crypto business in Dubai, which a lot of crypto businesses do. Not at all what was represented to the court. Sanctions, the gavel comes down, boom, SEC's got to pay the expenses of the defendant in that case. And there's this great quote I want to read to y'all. The SEC from the judge, the commission's above discussed conduct constitutes a gross abuse of the power entrusted to it by Congress and substantially undermined the integrity of these proceedings and the judicial process. There you go. So what we've been saying as followers and people participating in the crypto ecosystem, various ecosystems, whether it's XRP or others, a judge finally sees it and a judge called him out. Megan, thoughts?
Yeah, it's an interesting case. When you look at first the TRO and having not only very, very little, if nothing, to substantiate the claims that the SEC is making, but then also the potentially long-term and harmful effects of allowing these companies, or potentially more companies in the future, to go into receivership. You're looking at a pretty detrimental impact on a lot of crypto businesses, because even though the judge made the right decision here, there's still an issue of what is the SEC going to do in the future, and how are these entities, how should they best respond?
The SEC's enforcement director filed a filing as an appendix to the SEC's response, where he says, Your Honor, just a mistake, just a mistake. Trust me, we got to fix this, won't happen again. That's not the kind of response the SEC would ever be satisfied with a defendant in a case or with an internal investigation. But that's the best we got from the SEC. There is a fine. Hopefully that's meaningful, but we'll see. For now, it's a win for justice. It calls out the SEC's broad abuse of crypto. It's just one example of a broader pattern in the SEC's enforcement cases against crypto firms, particularly on just failure to register where there's no actual fraud going on. I also want to call out and just mention the folks at Morrison Cohen in this case, and Jason Gottlieb in particular, who's one of the leading attorneys in this that managed to get this win for Debtbox. So, Jason Gottlieb is another one of those we admire here on the podcast. And I want to put up just for a second the Morrison Cohen Crypto Litigation Tracker. It's a great resource. I like to use it to keep an eye on the latest in crypto litigation. Keep just an understanding of SEC litigation, administrative proceedings. It tracks two different types of crypto cases, if you want to divide them up into basically registration cases, registration-only cases, failure to register, and on the other hand, real fraud cases, actual frauds. Now, when the SEC is bringing a case that's got actual financial fraud, whether it's against a crypto defendant or anyone else, where there's real fraud, real material fraud, I'm going to be their biggest cheerleader. And I'm going to clap on the sidelines. I think John Deaton would. Megan, I assume you would. Where there's real material fraud, go SEC, go get them, go get the bad guy. But that's not true of most of the SEC's enforcement cases in crypto. And in fact, a lot of us in crypto say, why don't you go after more of the scams? There's a lot of pump and dump scams in crypto that we hate, that are not a part of the ethos we're trying to build as people building in the cypherpunk ethos, or as at any of the institutions where TradFi touches crypto. That's not a part of what we're trying to do. Get them out of there. Get them to stop pretending they're crypto. That's not real crypto. And most of the time, these pump and dump scams aren't even on chain at all. They don't touch a real public blockchain at all. We would love for the SEC to go after them, but most of these crypto cases, and especially in the registration-only cases, are about failure to register in a regime where it's impossible to register. And that's what's reflected in a lot of those cases on the MoCo Crypto Litigation Tracker, the registration-only cases.
And then, Professor, to go off of that a little bit more, is you don't only have a failure to register on the company, you also have within these trackers cases under 17B, where you go after the celebrities, the influencers, the touters of these sorts of cryptos, and not only the implications for the companies, but these individuals that get thrown in with an agreement, and whether or not they even understand what a blockchain is or have the type of expertise to know whether or not they're even violating this law.
That's a great point. That's a great point. Poor Kim Kardashian, right? Let's give a shout out to Kim. Kim Kardashian had an advertisement on her, was it TikTok page? I think it was. So Kim Kardashian had an advertisement on her TikTok page endorsing some crypto project. It said paid advertisement on the TikTok video. The SEC went after her anyway and said it's not enough to just disclose it's a paid advertisement. You have to disclose the amount you were paid. Which is that worth the SEC's time?
There's also the question of, if you're not paid in US dollars, what amount are you disclosing? Are you disclosing the US equivalent? We don't quite know.
Excellent point. Excellent point. Thank you, Megan. All right. So I want to move to a theme that I keep seeing in these cases over and over again. And I want to normalize, I want to get you all acquainted with a new, just a way to describe this. So when there's this great leader in securities regulation, he's since passed away last year. His name's Harvey Pitt, who I admire a great deal. He was always kind of a sage when it came to securities regulation, securities enforcement. He was one of the smartest guys ever to be chairman of the SEC, and there's this legend that he would do his work as chair of the SEC, but he would also go over to the enforcement division and he would mark up individual complaints because he was such a securities law, detail-oriented securities lawyer. When he did his first stint at the SEC, when he was general counsel of the SEC at the age of 30, he stepped down and he had this prescient article where he talked about the problem of regulation by enforcement. He was the one who first coined that phrase. And this is a phrase that describes so much of what happens in crypto, which I think is unfortunate. Regulation by enforcement. There's no clear rules, but the enforcement lawyers come in and say, either by way of settlement that creates new rules or by way of the threat of regulation or even now the threat of examination that just, in this case, sort of leaves the signal of don't work in this industry at all. He was prescient about that, but that phrase to me at this point is not quite enough when we see what's coming from the SEC. When we see examples of cases where the SEC starts off like they did in the library case, looking for a $20+ million settlement, and then seeking disgorgement in $20+ million. And library comes back and says, whoa, 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 you're not allowing us to deduct any expenses. Disgorgement awards have to deduct business expenses per the Supreme Court's ruling in Liu versus SEC. And eventually the SEC gets a small fraction, typically about 5% of what they initially seek in disgorgement. That leads you to question, maybe disgorgement was not the goal at all. Maybe bankrupting the defendant was the goal. And we see this fact pattern over and over in these registration-only cases in crypto. That's why I call it regulation by destruction. It would make a good band name or a good band album, but I think it's a good descriptor, too, of what the SEC is doing here. Megan, thoughts on abuse of disgorgement and regulation by destruction?
Well, regulation by destruction, I think, is a phenomenal way to put that. And disgorgement in particular has an interesting topic. I think you highlighted it all extremely well, but regulation by destruction is definitely what's coming up in not only your piece on Liu, but then in the A Mosaic Approach piece that we're talking about as well later on.
That's it. Let's head there. So one of the reasons why I think it was so great to work with you on this piece that we wrote was you were in Commissioner Peirce's office. She is a hero. She is the heroine of crypto. She is crypto mom. And not because she has any particular interest in this, but because she cares about the law. She cares about securities law doctrine. She cares about clear rules of the road. She's a good faith regulator. That doesn't mean she would go easy on crypto. I think she'd be as tough on real crypto fraud as anyone. But she cares about rules of the road, and she's a good faith regulator. So you worked in her office. We did an article that talked about kind of the macro and the micro, that dug into SOB 121 and the accounting bulletin and the surprise accounting guidance from the SEC on custody crypto, basically a shot across the bow to try to hurt Coinbase and some of the other banks like Anchorage. And on the other hand, take it macro and look at major questions, doctrine, defense, and just affirmative defenses against the SEC and how this could come together. So we kind of took micro and macro, and we merged them together in the article to this kind of mosaic theory. Let's start with SOB 121. Go.
So SOB 121, it's a staff accounting bulletin that was promulgated by the SEC. What's interesting about any staff accounting bulletin is that it's an interpretive rule, which meant that, as Professor Verrett pointed out, they just published it. There was no comment process. There was no review process. It was just an idea and a guideline that the SEC posted. Now, normally, these interpretive rules do not have the force of law. That is why it's an interpretive rule and not a rule. However, as Commissioner Peirce mentioned in a lot of her public comments, is that the language of this SOB 121 is extremely different. It's obligating outside entities and entities that the SEC wants to regulate to disclose any crypto within their custody within their balance sheets. So looking at this grand approach, you have two implications. The first one is under the Administrative Procedures Act, which, as we know, those are the guidelines for which an agency can act. And here, the question is whether or not they've overstretched. And we argue that they have. They've stretched their authority in what they can do by issuing it through an interpretive rule. But not only that, there is the never-ending argument of whether or not the SEC can even regulate crypto because, in part, of the major questions doctrine. When we look to Congress, no one has given the SEC authority to regulate crypto. So why can they do this? And really, the SEC doesn't have a clear, great answer.
So this was, I think, the excellent. And the idea behind this article, here's what I can see playing out here. There are these great arguments in Coinbase's action and Ripple's action, even in the Wahi case, arguments about the major questions doctrine and the fact that the SEC is trying to regulate something it doesn't have the authority to regulate. It was never empowered to regulate. A major economic question that requires Congress to speak to it specifically in authorization to the agency. Is a doctrine that's growing, is a way to swing the pendulum back from things like Chevron deference, the administrative doctrines that generally kind of fed the growth of the administrative state. So the idea is this. The first thing the SEC is going to do, as Coinbase and Ripple and others bring these major questions doctrine arguments that you don't have the authority to do this, is they're going to say, well, this is just limited to your particular case, and your particular token, or the tokens at issue in your particular issue, are a small part of the American economy, and therefore they're not a major question. And so what we're arguing here with the mosaic theory is, no, that's wrong, because that's not what the SEC is really doing. They're taking a throw as much as you can against the wall kind of approach here, a shotgun approach to get crypto, and a politically motivated effort to say, let's go after crypto on examination. Let's go after crypto on SOB 121. Let's go after crypto on a new custody rule for investment advisors that strongly discourages VCs from taking custody and is kind of blithe about the fact that banks are discouraged to take custody on the banking regulatory side, and the kind of Operation Choke Point 2.0 going on there. It's a broad-based issue. It's the new dealer definition that's now being sued by the Managed Funds Association. It's the new definition of exchanges to try to rope in all the DeFi as an exchange, which is impossible because there's no central party that could even be the registrant in DeFi. So you have to take a mosaic view of all of these things the SEC is doing in examining whether the major questions doctrine requires nullifying a particular enforcement action. So it argues for taking a broader macro view because all of these things are linked together, and it would be a mistake for courts in reviewing this not to take that mosaic view. That's the idea. If we could put up the article, there you go. That's a little quote from it describing the kind of mosaic approach we argue for major questions doctrine review of SEC cases. This is basically a playbook that we wrote in article form to help Ripple win, to help Coinbase win, to help Kraken win. This is our playbook. We put it up on SSRN. And let me ask you something, my friends out there in crypto world. Even if you don't want to read it, I hope you read it. But even if you don't want to read it, click that blue download button. It helps Megan and I. Think of it in your head. Every time you click the blue download button, think of it like if you're at a carnival with a friend who's sitting out in a dunking booth, and you respect them, but every time you hit the thing, they get dunked in the water. Think of Gary Gensler, a friendly little dunking in the water for Gary Gensler every time you click the download button for Megan and I's article on the major questions doctrine. So please go to that website. Please download the paper. We'd love to get your feedback on that. That's all I have for today, just to keep things within our window. But last thoughts, Megan. And anything from, you were inside the building for a little bit. You've had an opportunity as a up and coming Jedi Master Securities and corporate lawyer. You've been inside the building at the SEC. You've seen it work from the inside. What do you think? We've got hope? Do you think there are other people who think like Commissioner Peirce inside that building who can turn things around in the future for us?
I think that there is definitely hope, but not only looking to the SEC building, but just down the street on Capitol Hill. We have Senator Lummis, and we have the Financial Services Committee within the House that has put a bill on the floor. They are planning to rescind SAB 121. Now that has to go through the House, that has to go through the Senate. There's a lot of work to be done, but we have allies, and we have allies in Capitol Hill, which is something that gives me hope.
There you go. I like to hear it. All right. Thanks, Megan. Thanks, everybody, for tuning in. It was a lot of fun. We'll see you again for a few more of these. I know there's a few guest hosts here filling in for John Deaton. Nobody can fill in for John Deaton. He's a great John Deaton. Much respect for him. I finally remember the day the Ripple case came out. I sent him a crate of oranges in honor of the Howey test in his fight. He's a warrior. He's got a new fight. He's bringing Massachusetts. So a few of us are going to come in and fill in for him here and there and have a lot of fun talking with all of you. Thank you for tuning in, and up only.